Hey everybody, it's attorney Jason McGrath, and this is another segment of Carolina contracts. This is another segment dealing with arbitration provisions in contracts. With regard to your arbitration, you want to make sure that the arbitration clause or somewhere else in your contract deals with where the arbitration is going to take place and what state's laws apply. Now, if your contract is well written otherwise, then you have other parts of the contract, and I've discussed this in other video blogs, that deal with these issues, and the language is broad enough that it would include any arbitration. But you want to make sure of that. So, if you are a North Carolina company, for example, and based in North Carolina, presumably you would like the arbitration to be on your home turf, and probably you would like it to apply North Carolina law to the extent that you have a choice, and you often do. So make sure that that is addressed in the contract. The last thing you want to do is be dragged into a mandatory arbitration in California. It's going to cost you a whole lot more money to deal with a lawsuit or an arbitration out there as opposed to, more locally to you where you're located or where your attorneys are located, presumably here in North Carolina. So be very careful about that. This can absolutely impact every part of the case, especially when you're talking about what state's law applies. So basically, do you want California law to apply, or do you want North Carolina law to apply, or some other state? And if your contract doesn't address that, there are some, I'll just say, funky areas of the law that actually will allow another state's law to apply, perhaps depending on where the contract was physically executed, who was the last entity to sign it, that kind of thing. So make sure you're addressing that across the board, including what happens in those regards if in fact there's an arbitration. So just be mindful, be careful. Thanks.